Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about the finance charge laws. And in particular, we're going to talk about credit acceptance, charging excessive uh, interest rate charges. And while working on a summons complaint for a client, which I normally would not do one if it's going to be with the original creditor, because mostly you're going to end up, in a settlement type situation, which there's nothing wrong with that either. But I tell people to focus more on trying to have some type of resolution. But when I reviewed this one with credit acceptance, with that was the lender, credit acceptance, and I was like looking at the contract that they had with the client, and some of the things that she had let me know about. I was like, this might be, might be something that we should go ahead and at least, give it a shot. Let's just see what could happen, because you never know what could happen from putting in that work. And while I was doing my research, I had found that Michigan, and this is specifically for Michigan, that Michigan has a law, which all of the states have laws on what you can charge for an auto loan, the interest rate. Their interest rate max that you can charge is 25%. I'm gonna get it pulled up here on my screen. The most you can charge is 25%, and look like I lost that browser page. Here we go. Most they could charge 25%. I'm gonna have to pull that up again here. Sorry about that. Michigan. Here we go. So it's right here from the financial information for Michigan consumers, things to be aware of when obtaining a motor vehicle loan. Now, Michigan has a restriction on what they can charge you for the document prep, the doc prep fee. We've all seen this. It's a way that they can jump up the cost on for the vehicle. They'll say we had this doc prep fee. We have this fee for bringing the vehicle here. All of these fees they pass on to the consumer. Well, Michigan has where the doc prep fee should not exceed 5% of the cash price of the vehicle. So let's just say, for example, the vehicle costs $10,000 times 0.05. The maximum doc prep fee that they could charge is $500. And so, but I'm gonna get to how this one here, with also adding in another restriction fee that they have, which is the Michigan law limits on allowable finance charges to 25% of the vehicle. So Michigan has written into their law that no matter what, the fee for the finance charges on the vehicle cannot be past 25%. For this consumer, when I read the contract, it was 22%. This was very sneaky on what they did and how they did this. So it was 22% on the financing documents, but below it they had gap insurance, which is something that they added in there. And they also had the doc fee, and they also had a fee for the extended warranty. And unless they pay those costs, having those fees on there, unless they paid them up front, which they tried to hide it like they did pay it up front, this would actually be like adding on to the finance fees. So in essence, the way that I'm figuring it, I mean, when they go to court, they'll probably have to argue it back and forth. But the way that I'm figuring it, the total interest rate fee is over 25%, which is the allowable limits for the state of Michigan. And one way that we were able to figure that it's over the percentages is because this individual had been paying on the loan for 4 years, and they still owed more than what the vehicle was, than what they had originally signed for the vehicle, what they purchased the vehicle for. So just an example, this is what they paid, but the vehicle was $10,000 what they paid. They have the interest rate, they disclosed the interest rate, but later in the contract, they had the fee for the gap insurance, they had the fee for the extended warranty, and they did not disclose the fee for the doc prep. That was not shown on the documents that I was able to review. And then after making payments for 4 years, would you think that you were charged more than 25% interest if you still owed more than the $10,000 that you had bought, when that you saw on the sticker price of the vehicle after paying for 4 years? That proves that the interest rate is not 25%. I would say that would prove that the interest rate is actually 50% when they refigure it. With Santander, this was something that they did find out, that the interest rate was not what was stated on the contract. Also, if you look, Michigan has already sued, had already sued them, Consumer Credit had already been sued by Michigan and other states. Let me just look at some of the other ones that have been sued. I'm sorry, Credit Acceptance has already been sued by, they have been sued by the state of California, they've been sued by the state of Michigan, Massachusetts, and Mississippi. They just did Massachusetts, they actually did, Massachusetts last year, 2021. So, be aware of those. So now I'm going to talk about so with the response that we did for this client, I'm going to tell you some of the things that we put in the defense. Number one, top of line that we would want the judge to review is that we said plaintiff or agent of the plaintiff, auto dealer / auto dealer, because that's who would be putting the paperwork together, because she stated that the electronic document that they submitted as an exhibit was different than the one that she recalled signing. And they added gap insurance without disclosing. She believes that that the finance charge was over 25%, and that with the combination of gap insurance, doc prep fee, and the extended warranty, that the overall finance charges exceeded the Michigan finance charge law limits. Other things that was argued in it was we have repeated again that they did not disclose the doc fee, because remember, it can only be 5% of the total cost, which I think that it should be actually lower. I think that it could be lower. Let's see here. It said, is there a maximum on the doc fee? Is there a maximum? On this one right here, it did not have a maximum amount of whichever is less. Reviewing, it says here 5%. Actually, there is a maximum. $210 is the maximum. So if they charged over if they charged $500, that would have been over the maximum fee. Now they might try to disguise that by saying doc prep fee and these other fees were in there, but the way that the law looks at it is that if you have a doc prep, that's everything with the document. You can't say this is the doc prep fee for this portion of the contract, and then we had these other fees for this other portion of the contract. The way that they stated here is a doc fee is a doc fee is a doc fee, and the maximum is $210 or whichever is less. So if you bought a vehicle that was that would make the doc fee less than $210, you're supposed to be able to pay less, not just the 210. So watch out for that, especially when you're dealing with used car dealers. Another thing, they had stated that they had been trying to get information to her. Address was totally incorrect. She doesn't even believe that the gap insurance that she signed for the gap insurance on her original contract, they do show it on the digital one that they sent over, but she shows that on the digital one, it says that they made a certain down payment amount, and she knows for sure that she did not make that down payment amount, that document in itself is fraudulent. Loan amount is incorrect. They put a kill switch on the vehicle, which she was not notified of a kill switch on the vehicle, regardless of what type of loan you get. If they put a kill switch on the vehicle, you have to be notified of that there's a kill switch, because you could be putting your family in safety in jeopardy. You could be out somewhere. Yeah, they have a right for their vehicle because it's secured, but you could be anywhere and then you can't get your family back home safely. So they have to disclose it to you. They could turn it off when they want to turn it off if you don't pay. And they have to disclose the terms of being able to turn off that kill switch. Let's see here. Also, we did state in there that some of the information about the previous problems that Credit Acceptance Corporation has as acting as a debt collector. In most states, a finance company cannot act as a debt collector. A lot of people don't know this. In my state of Wisconsin, they can't. Also in the state of Michigan. So they cannot call you and say that this is in an attempt to collect the debt and their credit acceptance is calling. They cannot do that. And other finance companies cannot do that. They have to give it to a debt collector, and that debt collector has to do the debt collection portion. And we believe that that's a violation. And then reiterated again that excessive interest rates were not disclosed. Original amount was $13,500 down payment after making payments for 4 years. Only a little under $700 and something went towards the principal on the vehicle. So this is if you have any dealings with Credit Acceptance, any dealings with Santander, any dealings with any of these subprime auto lending companies, look at your paperwork, and the resolution could either be where some people ended up getting their vehicles, like in Santander, title, forgiven of the debt. If you've already lost the vehicle, they've repoed it and they're just coming after you. The same information could be used to win the lawsuit against them or get it dismissed. If you have the vehicle, it's not in the, you're not maybe in one of the states that is doing a lawsuit, you could potentially get a good settlement where they could say, hey, there is some wrongdoing, and a judge could make them sit down with you and try to come up with a resolution where you get a settlement. In some of the settlements that happened for people who had pushed it to the limit with Santander, we had one that got her vehicle for $1,300 and she had actually owed $13,000. So that's a 10% settlement, and she kept pushing that to the limit. So this is some good information. I'm going to keep doing my research. We still haven't seen anything on a nationwide class action, really any new news on it from credit acceptance, but I'm pretty sure if this keeps happening, that there's going to be action that will start speeding up on that. All right, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, where you can see my 8-point validation process, my two-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com. Links are below this video. You can get all 3 credit reports, all 3 scores. If you have debt collectors coming after you, grab my pack of three free letters. It is free. I do ask for a donation. Someone had said if it's not free, why say it's free? It is free, but we have had some issues with Gmail for some reason. If when you fill out the form and you get it sent to you, some Gmails are not receiving it. All you have to do is drop us a quick email at support@thecreditrepairshop.com if you don't get it. Only if you don't get it. Some Gmails are going through, some Gmails are not. We'll get those 3 letters to you. It has a statute of limitations letter, debt validation letter, and the cease and desist collection activities letter. If you haven't subscribed to the channel yet, please subscribe, ask your questions, post your comments. This is Stephen A. Williams, President and Founder, CreditRepairShop.com.